after an initial consultation with a lawyer. One of our last videos addressed the question of what happens during an initial consultation call. If you haven't seen it already, I recommend you go check it out after this video. Today, we're going to deal with what happens after that initial consultation call, assuming it went reasonably well. If you know when you hang up that you want to pursue other options, that's totally fine too. But in that case, I suggest that you let the lawyer or her assistant know via a brief, polite email. This isn't required, and most lawyers will take the hint if you don't, but I've worked at firms where the partners force their associates and staff to pester prospective clients via recurring emails and phone calls until they get an unequivocal rejection. This is an absurd and annoying practice, and I promise you that the staff hates it just as much as you do. But the best way to put a stop to it is to close the loop and flatly decline the services rather than try to ghost. As a mid-level attorney, I was once required to pester a guy every other week or so for over a full year after his initial consultation, just because he never wanted to give us a clear no thanks. The whole thing still makes me cringe. Now, assuming that you're either certain you want to proceed or you're on the fence, here are a few potential next steps to keep in mind to keep the process moving forward. Send your follow-up questions via email. First, you are allowed to follow up via email for any non-substantive questions that weren't covered on the phone. I specify non-substantive or non-legal because the lawyer is not going to be any more inclined to give you free legal advice outside the attorney-client relationship in writing any more than she was verbally during your consult call. But especially when the lawyer only allows 15 minutes for an initial consultation, it's not unreasonable if you realize after the fact that you didn't have time to cover everything and you need a little more information to make your decision. Be patient because the lawyer may need to address her paying clients' time-sensitive emails first, but the lawyer or her legal assistant should be willing to send you the information you need. Next, seek additional consultations. If you're seeking an attorney through Google searches, bar referral resources, or similar means, I think it's a great idea to have more than one consultation call, even if you love the first attorney you speak with. In fact, even if the lawyer was a direct referral from someone you trust who's used that lawyer before, talking to more than one attorney can be useful to compare background, demeanor, cost, strategy, and more. Again, an experienced lawyer can typically tell when you're calling a dozen people off the web trying to piece together a free legal strategy, so please don't do that. But you absolutely are allowed to speak to multiple lawyers to compare approaches and costs and decide which is best for you. Review the engagement letter. Again, just because you receive an engagement letter does not mean that you're obligated to sign it, although you shouldn't expect a lawyer to continue to be readily available to you until you do. But reviewing the engagement letter is useful to ensure that its written terms align with what the lawyer said on the phone, and you can and should address it immediately if you feel like there are any discrepancies. You can ask this lawyer questions, or you can share the document with another advisor you've engaged for other issues to confirm it's aligned with market practices and ethical standards. I've certainly helped my own business law clients review engagement letters that they've received from litigators or other practitioners who perform services that I don't offer myself. Then sign the engagement letter and remit the retainer. So once you've spoken to all your attorneys, you've had all your questions answered, you've reviewed the various engagement letters and agreed to it in principle, you're ready to move forward with somebody specific. I'd encourage you to go back through my past videos and stay tuned for future videos for more on the purposes of the engagement letter and for retainer deposits. But once this step is complete, the attorney-client relationship is formally established. Then you need to prepare additional documentation. So whether you're dealing with a corporate transactional matter or a litigation matter, it's pretty likely that your lawyer has requested you send over some existing documentation. Please be mindful to locate this documentation, organize it in a reasonable manner, and deliver it to the lawyer timely, with electronic transmission being the preferred method rather than FedExing hard copies for almost all attorneys. Oftentimes, we can't proceed until that documentation has been received and reviewed. And if it's a disaster when we get it, if it's unorganized, incomplete, illegible, or it's hard copies that need to be scanned in by staff, or the wrong documentation is sent, this delays our ability to move forward and it adds to your legal costs unnecessarily. We don't like charging you for this when we know it's avoidable with just a little bit of extra effort and attention on your end. So if you want us to jump into your matter promptly after the engagement is established, please be mindful to have your document requests prepared diligently and in advance. Remember, just as there's no requirement for you to engage a lawyer just because they had an initial consultation call with you, the lawyer has not taken you on as a client or established an attorney-client relationship just because they expressed a general interest in possibly moving forward with your matter. Although it is true that an attorney-client relationship could be deemed to exist even in the absence of a written agreement in some circumstances, when the action and conduct of both parties implies mutual consent to the relationship, there's reliance on the attorney's advice, and there's payment for services, this varies by jurisdiction, and the general rule that you should abide by is that no attorney-client relationship is established until an engagement letter is signed. Business owners. How can lawyers make the initial consultation and onboarding process smoother and more useful for you?